All rise. Grafton County Circuit Court's back in session.
All right, go ahead and be seated, please. We'll start with a call of the criminal docket. This is 2013-254. State of Arkansas versus William J. Lewis. Court is making the appointment of the Public Defender's Office to represent Mr. Lewis for arraignment on a charge of theft of property, theft by receiving possession of methamphetamine and fleeing on foot.
Your Honor, to all the charges, the defendant, Mr. Lewis, would enter a plea of not guilty. We would waive any arraignment on this matter. Judge, there is a parole hold on Mr. Lewis, so bond is not an issue today.
Judge, if you could correct the scrivener's error on the information, there's a Class A misdemeanor, not a Class D misdemeanor. That was a carryover from probable cause affidavit. That's a scrivener's error.
This case is assigned to the Division 4 docket of this court. At this time, the court is setting it down for trial.
Continue Monday.
April 21st and 22nd of 2014.
I don't understand this Class A.
It's set for pre-trial on March 6th. And the court will order it for a reappearance date of February 6, 2014. There'll be a written scheduling order containing those dates and other dates that will be filed in this case.
Potentially.
2013-251, the State of Arkansas versus Joshua Ray Theobald. For arraignment today, there's also a case 2010-61, a revocation proceeding. Once again, at this time, based on a review of the affidavit, the court is making the appointment of the Public Defender's Office.
Your Honor, at this time on both the new case and the revocation case, I would enter a plea of not guilty on case number 13-251 and case number 10-61. Waive formal reading of the charges and any arraignment. Your Honor, I will tell you that Mr. Kincaid has made an offer in this matter. I've shown that to Mr. Theobald, and he has agreed to accept that. It will need to be written up, particularly on the new charge. So if we can bring him back at one, Judge, we'll have a plea on this.
Okay. I'm going to set the revocation matter in case the plea doesn't occur. I'm setting the revocation matter for November. Let's see, this case is on Judge Putnam's docket. I'll set the revocation matter for hearing on October 31st. 2013-252, State of Arkansas versus Chadwick Whitlow. Based on the affidavit before the court at this time is appointing the Public Defender's Office for arraignment on charges of residential burglary, Class B felony, theft of property, Class B felony, and criminal mischief, Class B felony.
Your Honor, to all of the charges, the court announced Mr. Whitlow would enter a plea of not guilty, waive formal reading of the charges, and waive any arraignment.
Court once again is setting this case for trial April 21st and 22nd, 2014, pre-trial March 6th. And reappearance will be ordered for February 6th.
Your Honor, I do want to address the issue of bond with Mr. Whitlow before he's excused.
All right, we'll take that up at this time.
Your Honor, I believe the file will reflect that Mr. Whitlow is currently being held on a $50,000 bond. Is that correct?
Yes, that's what the file shows.
Your Honor, Mr. Whitlow has told me that he obviously cannot make the $50,000 bond, or he would have done so already. This gentleman resides and will continue to reside at 427 Waymire Loop, which is in Mountain Home. He will reside there with his mother, whose name is Brenda Whitlow. He's lived in this area for 12 years. He is employed by Bennett Transportation. Your Honor, the most of any bond that Mr. Whitlow could make would be a $20,000 bond. We would ask for a reduction to that amount. That's still a significant bond, Your Honor.
What says the state? I think if I remember correctly, reviewing the affidavit, I think that amount of $50,000 comports with the estimated amount of damages and
That does, Your Honor.
that was the property taken in the alleged offense. So,
Also, there was some matter of deception when law enforcement was encountered. They did not tell the truth. They attempted to employ a scheme to evade being arrested for this. Further investigation resulted that their story about their coming into possession of the property that they torn from the building was not true. It was a matter of deception, and they're dealing with law enforcement as well.
Your Honor, again, those are allegations, as they always are at this point, and I would again renew my argument to the court that a bond of $20,000 is a more than significant amount to ensure that this gentleman will reappear in this court.
given the nature of the alleged offense and what's alleged in terms of the actions of the defendant to avoid arrest, court is going to be willing to reduce the bond somewhat, but I'm going to reduce it to $30,000. That'll be provided as a cash or professional bond.
Thank you, Your Honor.